South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.
We have a very esteemed panel with us today, as we have Purnima, who leads the legal and regulatory matters at Tata Digital. Previously, she was associated with Tata Sons as Vice President Group Legal. And prior to that, she worked at Intel as a senior attorney with Intel Capital, where she spent a few years handling legal matters across a diverse portfolio of venture capital investments in India, Asia Pacific, and the US. Purnima is admitted to the bar in New York, India, and United Kingdom as a non-practicing solicitor. We also have Dr. Raghavendra, who is a retired civil servant from the civil CSS of 1988. He's currently serving as a senior consultant IPR with DPIIT, Government of India. He has a rich background in the government, with the Government of India, where he's held key positions as a joint secretary with the Department of Justice, Ministry of Law and Justice, and joint secretary at the DIPP. He also had the privilege of holding an additional charge as Director General of the NPC from November 2015 to May 2016. He also served as a Registrar of Copyrights and served a tenure of 6.5 years and played a key role in spearheading the amendments to the Copyright Act in 2012 and also framing the copyright rules in 2013. He has actively participated in numerous WIPO, SECR meetings, Regional Comprehensive Economic, RCEP, FTAs, and other FTA negotiations as a member of the Indian delegation. He has been awarded a PhD in IP rights protection for text data mining and AI. Then we have Christopher, who is the Group General Counsel. He heads the legal function at Interglobe Enterprises and plays a key role in managing strategic legal matters that impact the various businesses in the group. A significant aspect of his role includes assisting the group's various businesses on structuring and implementing M&A, JV, and strategic partnership transactions. He has over 26 years of experience in the field of law. Prior to joining Interglobe, he headed the corporate and M&A function at Mahindra & Mahindra, a leading industrial group. He has also worked for several years as an external lawyer in law firms, including Jones Day, White & Case, and Trilegal. During his private practice, he has specialized mainly across cross-border M&A, strategic joint ventures, and commercial transactions, private equity, and VC deals. He has practiced both as an Indian advocate and as well as an English solicitor, working in various jurisdictions, including the US, Russia, and India. He holds a master's degree in law from King's College London and a bachelor's degree from the University of Delhi. Now, coming to the topic that we are discussing today, we are going to be discussing on how to effectively navigate investments and strategic partnerships with keeping a specific focus on intellectual property. We are going to delve into strategies which foster innovation through collaboration with external partners, and we are going to also address challenges of IP ownership, licensing, and how to ensure fair distribution of value generated from JVs. Our panel of experts will share insights, best practices, and their experiences when it comes to JVs or investments, and how they have as lawyers advised their businesses from an intellectual property standpoint, and how to derive the best benefit from the IP which are involved in these JVs and investments. So with this background, I'm going to ask the first question to Purnima. Purnima, what factors would companies need to keep in mind while structuring tech-related partnerships?
I'll just take that question in a second. Thank you for a generous introduction. When I saw the topic and I saw the list of questions, I called Naina and said, listen, this is exactly why I pick up the phone and call you. And I have other general counsels in the Tata Group call you and Gautam and the likes of them. So, but thank you for thinking of Tata Digital and having us on the panel this morning. Uh, your question is what? Could you
So
repeat that for me?
Okay, so for what
Thank you.
factors would companies need to keep in mind when structuring tech-related partnerships?
Okay, so when you say tech-related partnerships, I'm assuming it's not really a joint venture, but it's a digital company which is tying up very quickly with many parties so that it's doing a plug and play. So I'll give you an example. There are companies in the fintech space that want to launch quickly. You don't have time. You barely have time to catch up. So you typically tie up with other tech players, so you're not wasting time building, and you're really up to speed. Uh, a key thing to keep in mind in these tech partnerships, as the story goes, sometimes you're running faster and faster, and you wake up the next morning and you find you're still at the same place. And that's the pace at which the industry works. So for digital companies, these technology partnerships are critical. Who do you tie up with? How quickly can they deliver? How safe is how safe is the IP that you get? These are the questions that are uppermost on our minds. So Gautam's question is, what factors do we keep in mind? Number one is license arrangement versus SaaS. It's a key one. There are many issues. The key one being how much control let's assume that I'm the company that is I'm a service recipient. So the question then is, how much control do I want? Do I want it on-prem? Do I want it on my cloud? Is it okay if it's hosted on somebody else's cloud? Do I have the capability to maintain it? Do I have the capability to update? Do I have the capability to take care of cybersecurity requirements? All of that. So the first question always is license versus SaaS, and that really determines the structure of everything else. The cost matters. Cost is a factor. Cloud can be really expensive, especially for smaller companies. Another useful one is pre-existing IP. If I have pre-existing IP, more often than not, I'm keen to do an arrangement where I will own the additions and the accretions, modifications by whatever name called. You guys would know that better. But that's a key one. Who gets to keep the improvements? To give you an example, let's say I tie up to build a platform to run an investments portfolio, mutual funds business. The basics may be done internally, but you need somebody to ramp up. It's a lot of negotiation who owns that. The technology service provider would always want to own it, and they would also, for them, their model is plug and play. So if it works for one Tata company, it's going to work for many other companies, and they're going to want to take it there. It's in our interest, therefore, to not allow that. And if somebody is learning at my expense, cost-wise, I'm going to have to actually show that I own the IP. It doesn't get cleared internally otherwise. Local regulations matter. When we tie up with technology service providers, I'm careful at least till the Data Act sort of came into effect and is partially in effect. Which jurisdiction applies? We avoid GDPR. I avoid countries where you have jury trials. It's just going to take one case for my top line and bottom line to go completely bust. So California is gone, New York is gone, most of the US is gone. GDPR means the UK and the US are also gone. So relatively speaking, I'm happy in India with Indian law, and perhaps Singapore too. Yeah, I think these are the top factors really. Another key one is how receptive is the technology service provider to SLAs and KRAs. And a key question, do I want a product or do I want services? If I want a product to be built, and you sign a manpower agreement, it's going to go bust. So you need clear deliverables, clear timelines, SLAs, KRAs, and all of that. So these are the broad factors that we keep in mind, subject to additional stuff that you and Naina generally have to say to these matters.
Thank you, Purnima. That was very insightful. So now coming to you, we've seen the EU, and now we're going to touch upon AI a little bit. We've seen the EU has adopted the first AI Act. So how do you think India is perceiving this from a government perspective? Are we going to follow in their footsteps? Are we going to have an AI Act? How is this AI Act also going to impact cross-border collaborations when it comes to using artificial intelligence? If you could throw some light on that.
Thank you, Vande Mataram. I would like to thank ABA and especially Nikhil for inviting me to this panel. And it's a very important question. And we are EU. I'm a lead negotiator for IP chapter for India EU FTA. My colleagues from EU side always say that we are the one who write perfect laws, EU directives. You follow this. I said, I'm not a member of EU. EU 27 states are there, and Brexit happened earlier 28, and UK has gone, don't put India into UK's place to fill up 28. Of course, they come out with, always they address the issues first. GDPR, when data protection law needed regulation, they're the first one to bring. And when the Puttaswamy judgment happened, Aadhaar judgment happened, and Supreme Court gave directions to Indian government, okay, Bhaiya, draft a law. And then government appointed our own sweet former Justice C. Krishna to draft a report. When the report has done the cherry picking of the GDPR, the very first draft 2019 Data Protection Act had cherry picks from GDPR. But thanks to the current most dynamic and forward-thinking Minister Ashwini Vaishnavji for taking that, because the Departmental Parliamentary Committee, left, right, and center, introduced more than 80 amendments. Very difficult for government to take such amendments to the existing bill. The best way to withdraw that and think forward, because we are in Digital India. We are planning to bring out a Digital India Act. That is the next step over and above the Digital Personal Data Protection Act, which was introduced in a new form and approved by the Parliament. Of course, that has to be implemented. It's a great step they have done, because the exponential emerging technologies which are coming, not only AI, of course, the industry 4.0 manufacturing is happening from man to machine. It is a machine to machine manufacturing happening, Internet of Things, 3D printing, and lot of data-driven manufacturing, marketing, fintech, everything where you have a lot of digital databases. And this data protection is important, considering that they come out. So now, everything is run by artificial intelligence. And before I left, I appointed one Bangalore-based firm, Daksh. We selected Daksh and also Vidhi to draft a project report for the eCodes 3 project, how Supreme Court and 25 high courts have to use AI algorithms for functioning of the courts, whether it is a court management, case management, and various others. Of course, they have already introduced AI. You have the transcription facilities and other facilities introduced, but you have to look forward. But where is the act in India similar to EU Act? No, let me deal with the EU Act. When EU Act came, even my American colleagues was still negotiating with the industry stakeholders and the brilliant lawyers like you. But they were not able to finalize the matter with so many litigation cases filed before the US Supreme Court against the OpenAI's ChatGPT or Google Bard. Now they have come out with funny Gemini. Gemini is a twin, astrological, two faces. One face is smiles, one face, what kind of information it gave about our most dynamic, respected, beloved Prime Minister. So nasty. So that cannot be acceptable. Similarly, the cases are filed against them, and that is subject is basically, consent and compensation in copyright. You can't break the encryption devices, TPMs and DRMs, and start scrapping. Uh, Despite the authors and the right owners are fighting, no law has been introduced there. They are still thinking, but EU has done that. When EU came out, wow, thing happened. And all IP guys and lawyers like you started reading that. And the slowly, when it came, it normally it won't immediately become a law. Now the beauty is EU Parliament has passed, but it takes time. Making effective EU, it won't immediately happen. Only one delay is happening for our three new criminal laws. We need some time to make it effective. So it may notification allowing it from July or something. When 3.0 happens, Modi 3.0 happens, they will implement it. And then coming to this EU Act, that will get implemented in 25, 26, not before that. So, meantime, they are planning strategies. Each company is planning strategy, innovative strategies, investment strategies, and then you brilliant lawyers must be already working or in future will be working. But what is the EU Act? It's a little let down. It's a watered down version. Why it is a watered down version? Too many exceptions out there. The exceptions which EU has introduced in its digital single market directive for the copyright, especially they introduced the text data mining exceptions for research and education. Why they need to reinvent these things and water down the already given exceptions in the EU Act? EU AI Act is not to address the copyright issues. What they have done in Article 53 of EU AI Act and introduce exceptions and all that. They have to do the regulation considering the various issues pertaining to accountability, the transparency, cyber security, data protection, and various issues pertaining to AI creations, the way AI algorithm functions, the way AI is adopted in health sector, for instance, or any other sector, legal sector, because the AI is being used there. That they have not done. And another important thing is deepfake, big issue. You all know the issue in deepfake recently happened. South Indian actors, Mandana, and even PM came out that this is dangerous thing happening. There should be a respect. So what EU Act, plus points I'm going to talk about. So whether it is OpenAI or Google or Microsoft, whether it is a LLM model of ChatGPT, or generative AI models, or generative adversarial networks, or deep learning networks, or computer vision, these things, doing all new content based on the text or photo or anything, digital databases. Here, it should come out with a small summary. So what is your basic computation model? So how your technology functions and how you have accessed that data. Is there any consent and compensation is there? Are you getting that data from public domain? Or you are illegally breaking the DRM and TPM encryption devices and without respect for the copyright? And also you have to address the issues of various issues like the racism and the skin color, and also AI has the most problem is AI gets into hallucinations. That is a big problem. How AI hallucination has to be addressed? Best example of AI hallucination is recently one of the district courts in the US, young lawyer filed a petition based on an affidavit prepared by ChatGPT, which went into a hallucination and generated 6 citations with no district court or appellate court of US delivered those judgments. which has been delivered by AI. When that intelligent judge read those cases, he came to know that these are all fake stories created. And then lawyer has to apologize and pay, because judge is a nice fellow, he imposed only $5,000 fine on him. So how you, not only the deep fake, hallucinations it's going to address, most important thing is trade secrets. Thanks to the Law Commission in India, we don't have a standalone trade secret. We follow the common law principles, principles of equality and tort, and Section 27 percent of trade. But we need a trade secret law before AA comes, during this Amrit call, before India becomes a Viksit Bharat, and we should break the stereotypes, the mistakes which EU has done, EU Act should not do. Niti Aayog has, of course, came out with 2018 draft paper and AA
Sir, I
strategy.
think that's what the EU Act is also trying to
Yeah.
achieve in terms of,
Yeah.
stopping these kind of, like what you were talking about,
Yeah.
racial profiling and all of that. Those are the exceptions that they have brought about, right? I mean, and that I think that's a positive that we need to look at and see if India can adopt that as well, with deep fakes and all of that being challenges here, right?
Yeah, if you see after Niti Aayog came out with the national strategy paper in 2018, in 2021 they came with two-part papers and how to operationalize AI. This is advisory to many companies. The first part report came in February and second part report came in August. The first is basically the strategy paper. Second one is the guidelines to the companies to look into all these privacy issues and the transparency issues and cyber security, data protection.
I think we'll touch
and
upon
all
that
those
in the
things.
next question,
Yeah.
sir. So I'll just move to Christopher now. Christopher, so coming to you, based on your experience as an in-house counsel and being an external working in a law firm, how do you advise your businesses in structuring strategic partnerships from an IP perspective?
Being a lawyer, I'm going to start my answer with a disclaimer. So I'm not a specialist, an IP specialist, unlike you and Dr. Raghavendran. So I so my role, the way I see it as in-house counsel for a company that does for a group that does a lot of JVs, is to work with business from the very inception to ask the basic questions. I think that's the starting point. Obviously, once we identify what the issues are, then we'll go to specialists like yourself and doctor. But the basic question is, and this is sort of, I'm looking at it from the perspective of from my perspective, which is as an Indian lawyer with an Indian corporate, looking at joint ventures. So often the focus of the deal is not just the IP. Obviously, the IP is an important component. So I'm looking at a situation that's different from the one that we looked at earlier. So, but obviously that's a key purpose of the joint venture, which is, there is, let's say, a partner who has a IP which has a proven, which is tried and tested. You want to replicate that. You want to, monetize that in India. So, as an Indian partner, what is it that you are going to firstly need the IP for? What are the terms on which you're going to get the IP? So how is the foreign partner going to monetize that IP in India? Is it through a separate license agreement or technology transfer? And if that's the case, what are the license terms? Secondly, in terms of IP that's developed by the JV, how are you going to treat that? So, I mean, we can get into all of that, but basically the point is that as a lawyer, you have to ask these very basic questions because, oftentimes business people are not looking at those kind of issues. So, so, that is what I would see my role as, and I'm with a corporate group where legal plays a very integral role. It's sort of very closely embedded in the deal-making side of things. So I'll leave it at that right now. We can come back to those sort of more detailed
We'll touch
themes
upon
later. Yeah.
more IP issues when we
Yeah.
come to you. Purnima, coming to you, what are the measures companies adopt when they create IP? And to protect the IP, what are the measures that companies typically adopt?
Okay, so that depends on the type of IP. Let's look at trademark and copyright violations. So Tata IPL just launched on the 22nd, and this is typically a 2 to 3 month period when the number of the instances of online misuse is significantly high. It is disproportionately high in these 3 months for us, for instance, compared to the rest of the year. So there'll be fake websites that claim to be Tata New, Tata Digital, Tata something. And they'll say, okay, pay me 5,000 rupees and go and pick up your free tickets, right? Or fake job offers, fake use of, misuse really, not fake use, misuse of different Tata logos. So we use brand monitoring tools. There are brand monitoring tools that are constantly served, and you identify the top social media platforms that you want to regularly monitor. So for instance, for us, I would pick, say, Telegram, Insta, Meta, YouTube. YouTube is, I think, the maximum number of cases of misuse statistically seems, at least for this financial year, the ending, I think, day after, it's been on YouTube. So we monitor these regularly. We use third parties to do the monitoring, and then we have these pulled down. If they can't be pulled down quickly enough, you pick up the phone and I call my counterparts at all these different companies, and you request them. You need help. There's an understanding generally amongst general counsels and legal heads. So you pick up the phone and you seek help to have it pulled down quickly before the misuse. The misuse can be quick and it can be heavy. So you have these pulled down.
Yeah, I think also, I mean, that's a challenge. You pull down, like for example, a domain which comes up. You pull it down. The next instant, there's another domain with a slight change in the name of the domain. How do you tackle those kind of situations?
No, you're always playing catch up, and there are those John Doe cases that we filed. They come handy. They typically come handy for us this time of the year, and we've used it to our advantage. I keep telling our other Tata companies to do it, for that matter, other councils as well. That's one approach. And then so that's copyright, trademark, and misuse, digital misuse. There are, of course, companies that have actual products, Tata Tea and Coffee and Tata Salt, and there are counterfeits. So there's a separate department that does it in each company, but they do the fun stuff. They actually do the raids. Really? I used to work decades ago at Unilever, and these raids used to be, to be part of the legal training there. Then we come to patents. Honestly, the process in India is, I don't think difficult is the wrong word, but there's a chunk of development that happens that is related to software services, and those are difficult to patent. So I think there one just goes with the flow, or pick up the phone when in trouble and reach out to the specialists.
Thank you.
And if I may, I just wanted to add one point, which, since Purnima was touching on this issue of patent. So, in my previous role, I was looking at a couple of defense JVs. Now,
Sorry, defense?
Defense JVs.
Oh,
now,
okay.
So what happens in those cases is that, no defense company wants to register their patents, right? Because it's highly confidential. So your only protection in the Indian regime is then you rely on contracts. And then there's always the issue of enforcement, et cetera, et cetera. So Doctor raised this issue of trade secrets. So that's maybe something that we can talk about a little bit more, because that's of particular interest to me.
Yeah, we were discussing that, so maybe you can just touch upon that in the next question, because we are on the bit of IP issues. I thought I'll ask you this question. As an in-house counsel, what are the key considerations that you would, think of when with IP issues?
So continuing from the previous theme and the previous scenario, so if it's a situation where I'm dealing with a foreign partner and you're getting IP into the JV, so of course I mentioned earlier, what are the terms of the license? That's one important consideration. The other important issue that happens is, the IP that is developed on top of either on top of that IP, which is the background versus foreground IP, or it is other IP that is developed within the JV itself. Now, as an Indian JV partner, my concern would be, what happens if the JV breaks? Let's say, we've had situations in the auto sector, especially where the JVs have collapsed, the foreign partner exits the country. But the entity itself is valuable. It's got a good product. It wants to continue to supply that in India. So, are you going to be able to continue to do that? What happens with, for example, you're using a particular platform, and there are then innovations. There are new pollution norms, and there are solutions to that are available overseas, and you want to implement those in India. Are you going to be able to rely on the relationship? So the point, I think, to that is, in many cases, a JV is not just a JV, particularly when there's IP involved. So you need to think of the IP contracting as completely separate from the joint venture. So that's one key concern that I would see. The other issue is on the issue of, and this is looking perhaps more from the perspective of the foreign partner, which is that you have employees that move from company to company, and of course you have restrictions in their contracts that confidentiality and all of that, and then there's you also have these these kind of non-competes which are sort of difficult to enforce, etc. So a lot of this, their knowledge is there in their head, right? They don't need to necessarily take away documents with them. So how do you control all of that is always a continuing issue. So these are things that it'll be good to discuss.
So do you think a trade secret legislation like how Sir was proposing is something that is viable?
I don't know. I'd like to hear more. My one concern is that we open the room for a lot of adventurous litigation, and we become like the US. So in my my previous company, we were sued by a former JV partner in the US, and and the claim there was not copyright or trademark or anything like that. There was this concept of trade dress. So
It's a trademark issue.
it's not. It's more than a trademark issue. It's a trade dress issue. The product, the kind of the side profile of the product looked like something that this other company was producing. So that is always a concern, that we build this room for Indian corporates because we are sort of on an upward curve, right? What we don't want is a situation where our opportunity, our chance of catching up is going to be stymied by a lot of litigation. That's something that I think that concerns me.
Two issues raised by respective panelists. One is pertaining to the problem of patenting the software patents. Of course, 3K is there, computer program per se, algorithm not patentable. We follow the American Supreme Court decision in Ally's case, the same internationally follow. Any technical effect is there, then it is patentable. That's why, if you see the kind of patents are granted, we have crossed more than 1 lakh patents. That was a target set by the PMO, and we crossed it before the financial year ending. And if you see the latest WIPO Geneva report, the patents granted, the innovations are falling down all over the world. I'm talking about developed countries, EU, US, Japan. India, there is a growth of 44.2% in granting patents. You see kind of innovation happening around. Do you know India is the largest investor in IT in Asia Pacific countries? Our innovation index in World Innovation Index, Global Innovation Index, India jumped from 81st rank in 2014 to 40th rank last year, and it's maintained that we'll grow more. But coming to the trade secret issue, now there is a trade-off between the patent and trade secret. We don't have a law of trade secret. We have Section 27, Tantra Act, the breach of confidence, common law principles, tort rules, or the equity principles and all that. But the weak protection we do, any misappropriation comes, the civil remedies which follow not enough, we don't have criminal remedies. When theft happens, knowingly with mens rea happening, this will happen in this AI environment. You are lawyers for a company where their digital data cannot be copyrighted because there is no originality. Supreme Court judgment in Eastern Book Depot was a DB Motek that followed the American principle of minimum creativity, minimum degree of creativity, skill and judgment in the databases to be proved of originality test. If that is failed, you don't get a copyright protection. You don't have EU kind of directives like protection of sui generis protection for non-original databases. We don't have. We oppose it because copyright survives because of originality. Don't kill originality. Non-original databases we don't protect. We force WIPO to withdraw that draft treaty proposal when internet treaties were happening. And for patent, 3K is there, as she mentioned. But technical effective, India is top 10 AI patent granting countries. So considering all these things, I'm going back to EU AI Act, we need that. But government is already stepping into that. Then in previous intervention, I talked about the NITI Aayog paper on the responsible AI and implementing strategies for responsible AI too. Now Digital India Act is coming. Apart from various aspects which has been left out in the Digital Personal Data Protection Act, Digital AI comprehensively covering, including AI regulation. But recently, the Minister of State, Chandrasekhar ji, spoke about bringing out draft AI regulation framework. These things may happen soon. But we need a trade secret law. We need an AI Act separately for regulation, leaving the IP issues apart, because we need to amend the copyright law. We need to introduce text data mining exceptions, similar way the EU has done, Japan has done, UK has done in their laws. That need to be done. And then, it is transforming the AI. The low AI to strong AI, it is coming. The strong AI, you call it artificial general intelligence, which recently Elon Musk called the digital god. This is going to kill copyright. I replied on Twitter saying that no. Copyright law both took place because the emergence of technology called the printing machine, and it kept changing when new technologies came, new treaties came, and then internet treaties came to address internet issues. and encryption devices, DRM issues. And then the copyright thinking brains will come over with the new law address the AI issues which we have done. Recently there was a parliament question. The question came in Rajya Sabha that was immediately sent to me as an advisor, please drop. So I drafted and gave it to the senior officers. It was placed in the parliament. Immediately they issued as a press note, PIB press note came, that came in all the newspapers. What is that? The current IP laws completely address AI IP issues. Even Farid Alani case, Supreme Court, the Delhi High Court said that the patentability of software, the computer-related inventions, old guidelines are better than the newer guidelines, but you reframe the guidelines so that the innovations are respected and promoted, because India is the largest investor in IT in Asia Pacific. And we have a comparative advantage in the entire ICT industry. We need to protect that. And when India becomes the Vikasit Bharat, we have to break these stereotypes and we have to move forward. We have a new laws promoting innovation. That's what IP policy says, Creative India, Innovative India. We should not forget that. And then coming to copyright issues, there are general provisions are there which that at present protects. And we have an entire very concept of IP, what we try to say that in one sentence, that only a natural person, whether the patent inventorship or copyright authorship, will go to the natural person, not to the machines, because the entire IP based on two key theories. There are various other theories. I don't want to give a talk on that. One is the personality theory, because the Australian Supreme Court clearly said while rejecting the Dabus the patent, because the AI can't be recognized as invented, because the human ingenuity brings out the inventions, not the machines. So that's what the basic IP concept we follow, and also the incentive theory. So roti kapda pan makan needed for the natural person, not to the machines. That's why there is a term of 20 years for the patent, life after 60 years here. So what we need a separate Digital India Act that's draft will be released, because now there is the election code of conduct rules that cannot be released. It's already paka hua hai, and that will be served post-elections once results come out. And most probably the draft guidelines framework, AI guideline frameworks, will also be released for the public comments soon after elections. These are needed. But these things, the way EU AI Act, which fiddle with the copyright issue, that should not be done in India. But it should, whatever regulation comes, that should promote innovation, the growth of industries, use of technology for the human development, the country's development, and contribution of this industry to the GDP of the country, and also employment generation through whatever. And when this is happening, every country deals with these issues, whether AI regulation or IP related, considering their industry, their stakeholders. Because when cross-border issue happens, you lawyers will have problems in JVs and other contracts. So we should have an international norm setting, international treaty or convention addressing these issues, whether it are regulatory issues, privacy issues, or deep fake issues. All these things have international cross-border implication, including IP, of course, the copyright and related rights. International convention we need with the basic minimum standards. So those minimum standards, on that basis, our national law should work. So in India, going to be a leader now, already a leader in the ICT, so we'll lose our market if our laws, whether AI regulations or IP laws, when India becomes Vikasit Bharat. We are already almost Vikasit Bharat in many fields like ICT, other areas. So we should think in such a way in a forward direction.
That's good to know, sir. It's you've been saying that there are regulations in in place which are going to come about, which is good to know. So now I think we'll just open up for questions if anybody has questions, so that, anybody?
If nobody's putting their hand up, I have this question. Just taking off from what doctor said. He made this very good point that IP protection should encourage innovation. At the same time, it shouldn't defeat or restrict innovation. So when you talk about trade secrets protection, is there a possibility of balancing the need for protecting trade secrets while at the same time making it harder to start frivolous litigation that actually restricts it? And how have other jurisdictions tackled that?
Yeah, that all depends how we are going to drop the law. Of course, the Law Commission has given the draft legislation for this thing, but the economic espionage, that threat part that need to be introduced. And what my friend Justice Pratibha Singh said other day in one of the meetings related to trade secret, that every month in Delhi High Court, 10 important cases are filed on trade secret. And it is growing. And this will grow when the AI gets into the life system of each and every company, and the hacking will happen, and hacking can happen across the border, and theft can happen to put down your company, which is the main competitor in that sector. And also this comes in various ways, theft that need to be protected. To stop the frivolous thing, it is possible to stop the frivolous litigation because we have a theory at present legal system addressing the trade secret through the common law and all that. The very basic thing is there should be a contract that should have been violated by the person. There should be NDA that should have been violated. But what happened without NDA? I'm hacking your system. I am taking away your trade secret or confidential information. So that need to be addressed. That is lacking. Unless and until we move away from the present system, we can't protect the innovations which already happening and going to multiply. And the problems will multiply. The more innovations happen, especially in digital databases associated with marketing, financing, and everything.
Okay, thank you, sir. I think we're out of time. I would like to thank the panelists for this insightful discussion, and thank you for your time.
Thank you.
And thank you.
Thank you.
South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.